Ladies and gentlemen, boys and girls, welcome back to another episode of All Things Litigation Funding. My name is Ted Farrell. I'm the founder of Litigation Funding Advisors. Today, we have a terrific guest, someone I've known for many years, knows everybody in the business, and I think, as you're going to hear, probably has about as deep and broad experience as anybody in the space. Huge round of applause for Mr. Evan Fried. We get a little intro and background here.
Thanks, Ted. Evan Fried here. I'm a partner at Slarskey, LLC. We're a litigation boutique based in New York, where I have been approaching on 10 years at this point. Before joining the firm, where I was number two, I spent a bunch of years on the buy side in litigation finance. I've touched more or less every part of the asset class, from patent litigation funding to mass tort to frauds involving, personal injury litigation finance, law firm financing. The list goes on and on. My origins in the space date back to 2007. And for the past 9 or so years, I've been at Slarskey, and we are involved in a broad array of commercial litigation, including, as we'll talk about later, a bunch of disputes involving litigation finance.
Right. So let's get into that, because I think that is an interesting piece, because, most of these disputes you would have, I think, as most people will tell you, it's very common to have mandatory arbitration provisions. And so unless there's a real question of judgment enforcement, these things tend not to spill in the open. So give me sort of an idea of what the kind of like array of disputes you would see here. And, I'm interested to ask you, really, is this different than any other disputes you might have when there's, financing transactions, and kind of your thoughts on that?
Yeah. We are certainly seeing more and more of pure litigation finance disputes, right? Disputes between a funder and a client, or a funder and a law firm, whoever seems to be the counterparty on it. And you're right that not a ton of these are spilling into the public domain, because they are confidential. Most of the disputes that we've handled in the space fall outside of that, actually, where you see litigation finance be implicated. We've done a good amount of investment frauds involving litigation finance. We're litigating against a Ponzi schemer in Florida now, who was running a litigation funder. We were involved in a Southern District of New York bankruptcy that was also a Ponzi scheme involving a litigation funder. Both of those were on the consumer side. We've done a couple partnership disputes, and I guess the big one that we've handled, the biggest one that we've handled in the past couple of years, was a fee dispute between two law firms and their former client. They were all fighting over $125 million patent settlement. And, one of the key issues in the case, beyond liability, was how do you treat litigation finance? What happens when the pie is getting sliced a bunch of different ways, including to a litigation funder? So we're seeing it in a bunch of different areas, and pure fee disputes is just scratches the surface.
Right. So, if you show up at a litigation funding conference anywhere these days, there's discussion about how we're a real asset class. So are you telling me that the fact that we now have Ponzi schemes and scammers means we've really graduated and we're just like everybody else? Or what do you think sort of drives us?
I think that we're getting beyond that, frankly, and that may be the best evidence that this is a mature asset class. As in any asset class, crypto, litigation finance, life settlements, it doesn't really matter. You see the bad actors in the beginning.
Right.
You're looking at big outsized returns and, a very opaque asset class, by its very nature. In this case, you have multiple layers of opaqueness, including that the relationships with the end clients tend to be confidential. These are confidential settlements. There's attorney IOLTA accounts involved, which can be another gating issue of how opaque it is. I do think we've, there's some riffraff that has been weeded out of the space, particularly on the consumer side and the law firm financing side. But I do think that, the idea that there are $50 and $100 million or more frauds, it is evidence in some element that, the asset class is here to stay.
Right. So, this is interesting because I get, I was over the holidays, someone I know from home was in wealth management. And they said, oh, I represent family offices and they want to get in the space. And my God, these returns are great. And, what I tell them is, if you actually really want to do that, I'll give you the name of 5 to 10 really good managers. And you should take an LP position because, when done in a sophisticated way, in a smart and thoughtful way, you might actually be able to clip those returns, as opposed to you're going to pick the deal right off the street that everybody who's smart missed. So what are your sort of thoughts on that? Like, as, I'm an investor and I want, exposure to the space.
I think that's totally right. I think that, there's a big misconception as to how scalable exactly the asset class is. I think, maybe that, equity investors might have a new room for opportunity here with alternative business structures. But when you're talking about conventional litigation finance, be it single case financing, law firm financing, even the consumer litigation finance, there's this misconception in the institutional investor world that, great, we could just build more lawsuits, right, and finance more lawsuits like their mortgages, right? And it's just not the truth. You see a lot of fairly sophisticated first-time investors come into the space and think that they can do it better or different or anew from somebody else, and it doesn't always work out. The big institutional investors now, I think, are understanding you got to gravitate to the established asset managers who are doing it, and be prepared to get your, more modest returns if that's what you want as your exposure to the asset class. But it's certainly not a thing that, a mortgage investor can come in and say, I want to write $1 billion check because I can do it differently than anybody else.
Right. And two, and I think, we're seeing this sort of move towards, at least the sort of green shoots of, this, Arizona has this alternative business structure and this pot isn't around that. And people are saying, well, now I can get equity returns. And my answer is, well, you still have to still underwrite the risk correctly. And you can, if it was structured as a credit product, as a loan or an equity product, if the future cash flows are not there, zero equity and zero credit is still, to me, is still a zero. So let me ask you this: how did you guys kind of become this go-to firm in the space when stuff happens? I mean, has this been an outward marketing campaign? Is it, like a lot of, especially small law firms, where it's a really good referral network? Like, how have you guys built this into becoming, the people that you call?
Yeah. Well, first of all, I wouldn't take all the credit. I think that there are a lot of good lawyers throughout the nation who are doing this. On the transactional side, you got Doug Gruner in Chicago, you got Boris in New York, you got Mike Kelly down in DC. Right. There are, a club of 5 or 10 really, really good transactional lawyers in the litigation finance practice, or 10 groups kind of spread out throughout the nation. Right. Doing this type of work. In terms of dispute resolution, we are among the smaller subset of people that are doing it and kind of focused on it. When we founded the firm, or when Dave and I first started throwing ideas at the wall, we were marrying a bunch of litigation finance concepts, including aggressive plaintiff commercial litigation, greenfield analysis, and baking cases from the bottom up. The combination of that with litigation finance, as well as some legal, ethical, and malpractice work, particularly borrowing from some of Dave's experience when he was at Patterson Belknap, was doing a lot of the kind of highbrow work in that area. And it just kind of started coming to us. And we were focused on a really interesting time in 2016, 17, 18, where the commercial litigation finance market was getting really saturated. Everybody was chasing the $3 million deal. And we didn't want to play in that, certainly as a principal. And we were just trying to figure out how we become useful in that area. So we have focused a lot on that, particularly in the past couple of years. I'd say our 2023 arbitration was a big break, right? It was a nice, juicy piece of work that was, it was an arbitration, but I think it was very important in terms of how some of the authority will evolve in that area. And I think we got our first view around the corner as to what these disputes are likely to look like in the future and what the key issues will be. And we've kind of just run with that, bringing in Adam from Bernstein Litowitz a year and a half ago was a big part of that. Renee and I are doing the Ponzi scheme together down in Florida, and kind of the whole team here. And now we're 12 attorneys has really embraced this as a big part of our practice.
Okay. So I'm hypothetically, I work at a mid-sized law firm, and we want to do a funded deal. We've done a lot of contingency fee work, but we're sick of paying at least the out-of-pocket expenses, which just hang out there for years and years and years. So what do I need to think about going into these? Because look, what I see in these disputes, and again, like I read the arbitration you were in, and I sort of hear about them, is maybe everyone didn't go in eyes wide open.
Mm-hmm.
And so, and again, like, I don't want you to talk about a particular case you're in. I understand that. But, as this is relatively new, what are some of the things you've seen where, it's trouble coming right around the corner that maybe you would see coming, right? But a more nuanced, a more novice person, even if they're an outstanding lawyer but who's never done this, tell me the kinds of things to, you kind of tell people to look out for and think about.
Yeah, that's a really good question. I think that, there are a couple things that kind of clients or litigants or people interested in the space foresee, particularly on the law firm financing side, on the plaintiff directed funding as well, which is what are the funders' rights to cut off a litigation finance transaction? What happens if, there's a $5 or $10 million funding transaction covering 3 or 4 or 5 cases, and half of the lawyers dealing with those cases jump ship and go to another firm? That's an issue. And I guess more specifically, what happens? These contracts are generally fashioned the same way. It's a grade over a multiple or a percentage of the upside. What happens when that multiple gets really big? And I think, without any basis,
well, that's the best. That's what we count on in the show.
Look,
for our guests to come on,
it is
the opinions with zero basis. That's the whole key to the enterprise.
Well, that's the beauty of litigation finance. We're kind of just making it up as we go.
Right.
And no better host than you, Ted. Here's what I think. Prediction. You ready for a prediction?
Here it is.
All right. Here's my prediction.
2025. Is this a 2025er?
It's maybe a 6er.
Okay, that's fine.
Okay. It may be a 5er though.
All right.
I think that there is going to be, and nobody's talking about this, but I think there's going to be some really interesting authority about how to bring in quantum merit principles in dealing with litigation finance. Here's what I'm talking about. Lawyers are duty bound to keep fees reasonable, right?
Correct.
Okay. Based on the model rules and based on the model rules of every single state. Can you see, often is that prescribed? Yeah. You have, a third in a personal injury case, or, an escalating 25% to 35% to 45% if this was a commercial case. These, the metes and bounds of what reasonable looks like are pretty well prescribed, and what you can and cannot do is pretty well prescribed. Some court or some arbitrable body is going to come in and say, I'm going to right size a litigation finance contract. I'm going to say that the funder is taking too much because, or under the circumstances presented, because they cut off funding, right. I know the contract says what it says, right. But I'm going to come in and right size that. And I would welcome that authority. And I'd love to litigate that case too, because I think that, people take down litigation finance for all types of reasons. And at the end of the day, yeah, anybody could read a piece of paper and say, I understand that in theory, it says this. But what about the fact that there were delays based on COVID, or the judge retired, or this, that, and it became longer and more expensive than we thought. And we were kind of in a really challenging situation when we had to take down more and more money. And yes, I acknowledge I signed on that, but I need somebody to come right size this based on equitable principles.
Yeah, when I litigate against you on that, I'm going to say, if I'm the funder, yeah, who took the risk that COVID was going to take 5 years, and the judge was going to retire, and the judge was going to grant a motion to reconsider his summary judgment he had given 2 years before on the eve of trial, right? So those are risks. But I think it'd be very interesting. And look, that is always a tricky one. And usually with savvy borrowers, very heavily negotiated, because look, there's two schools of thought, and what we're talking about here is a situation where we will fund up to X dollars, but if there's a materially adverse event, we can pull the funding. So a materially adverse event could be anything, but let's talk about one that would be real. Hey, before the trial, the judge made a ruling that the expert is out. So you can have a trial on liability, but you're going to have to go up and appeal that Daubert. And so basically, does the funder have to put out $2 million to go to trial for maybe a zero? And what's often negotiated is questions of, is the party able to seek additional financing that comes in senior to that funder? If the funder has negotiated, and this is not usually in law firm finance, it's usually client side of, we get X% of the claim, right?
Mm-hmm.
Well, should you get that entire X% if you cut off? Now, conversely, that always seems like, oh, these funders left you in the ditch. But, let me give you the other side is, we filed a case and we lost at Rule 12, and we had leave to amend, and we actually amended and we added great new facts, and then we lost again. We want to now do a second amended complaint. Does the funder have to pay for your, for your sec? So these are all difficult, but I think what this is really a plug for is, call Evan when you're doing your deal, or call Evan, or call Michael, or call Ray, or call them, or use an intermediary, because these are situations where the parties need to bargain for these rights. And, look, these deals at the end of the day are about allocation of risk, right? So if you're a law firm funding, right, a law firm signs up a client and they own this illiquid asset where they own 40% of a recovery, which could be worth somewhere between 0 and 9 figures.
Mm-hmm.
And, the funding is a way to mitigate that risk and take some of it down. So these are all kind of things that if you think about them and you bargain for them at the outset, even in year 4, when the ball doesn't go your way, well, it's like, yeah, but we negotiated that, right? And we agreed that we would get this for that, as opposed to, wow, we literally never thought of that. That's tough.
I mean, the question you asked earlier was, what makes these disputes like or dislike any other old contract dispute? And I think the question there is, this a contract over a securitization of commercial mortgages, in which case a judge is going to look at the contract and say, this is it, this is all I need to look at. I don't care about the other stuff. Or is litigation finance more akin to a contingency fee agreement, where the judge says, I understand what this says, but this is the starting point, not the ending point. I'm allowed to take this contract, take it in context, and take into account other considerations, such as it required somebody else to bring in funding, just like it would be, if you brought in successor counsel, or this wound up being longer, or I don't like the idea of a plaintiff walking home with only 25%. I'm going to right size this and make sure they get more than 50%. You see this happen all the time in class action settlements, any type of court approved settlement, personal injury cases where a lawyer might overstep in the contingency that he or she requests. And the courts in those circumstances can invoke equitable powers to right-size contracts. And I'm just curious to see to what extent they will do that. And I guess maybe they are doing that to an extent because these are going on in arbitration. And, we all know arbitrators have a tendency to split the baby.
Because they want to get picked again.
Because they want to get picked again.
That's right. So you would not say anything to kill your chances of a future appearance on this podcast, my friend. You'll keep it just milquetoast enough. Okay. Let's move on a little bit. I know that, and I don't want to talk too much about it, but I think it does really make you sort of interesting, but also, how you think about this. You do some investing in litigation through your Graybridge platform, but how has that helped you underwrite your own firm's risk when you're underwriting risk in third-party cases?
Yeah, look, we, this firm has deep-rooted principles in litigation as an asset, and a lot of that comes from my experience on the buy side in litigation finance, funding, investment amounts up to $10 million, as well as, our interest as a firm in taking on risk and doing hybrid and contingency work.
Tell me what you mean. Tell everyone what you mean when you say from the buy side. What seat are you talking about there?
Yeah. So, before I joined this firm, I was an investor in litigation. We were doing funding transactions between $1 and $10 million, predominantly on patent litigation.
Well, here's why I asked you that loaded question, because I think this is really one of the most interesting things about the business is, so I started as a lawyer in private practice, seeking funding and using funding. And we thought we were on the buy side, right? Because we said to ourselves,
right.
You call up and say, oh, I hope we get off this call and these guys say, you know what, like, we do believe they stole your client's trade secrets and we have these $6 million for you.
Right.
And what you don't realize until you move over and work for a funder and now you're an intermediary, what you really don't realize is the person on the other end of that call whose job it is to find, underwrite, negotiate, close, and get a return. The greatest thing that can happen to them is this person on the other side who is dying to be able to get this money has the case that you can say, we found a great one and we're very confident in it. So I was just interested in you using the buy side as the funders, because the attorneys seeking the funding don't see it there. And look, it's symbiotic, right? It goes back and forth, but it really is, the law firms and the attorneys and the claimants, really have what's needed to make the whole business work, which is a claim that you can actually fund.
Right. Or it's, I guess the analogy could be like the insurer and the reinsurer, right? The lawyer's the insurer, and then the funder's the reinsurer. You're selling the risk off to that party. I think you hit the nail on the head, though. Look, we think of litigation. We're not the only ones, but we think of litigation as an asset, and
this is when you're talking about corporates. Not really. Look, someone gets injured, has a traumatic brain injury. It's not, they have to recover. But so I think what we're talking about here is, we're an institutional investor that lost money with Madoff. We had money in that, those kind of things. I mean, I think when you're talking about an asset, I just want to draw the line, because I do think the worlds of direct to consumers for physical personal injuries and commercial are very different. This podcast focused on that, but I just want to.
Yeah, I mean, look, and for sure, we teach our clients to think of it as an asset. How much do you really want to put into this? Is your money better spent doing something else? But we also think about it as a portfolio of contingency and hybrid cases. What risk are we willing to take on this particular case? And we're looking at the same factors that a litigation funder would be looking at, which is, liability, damages, collectability, time to money, everything like that. And
intervening change in law, change in judge, client is irrational, key attorney wants to leave,
for sure.
Budget, they'll never live at the budget. All these, right? All those things.
Yeah, exactly.
Well, the nice thing is, here, when they rip through the budget, it's kind of pejorative. In the UK, they just say they're coming back for a top off. That's what they say. They just need, and it's always quid, right? They just need like 6 million quid to get to trial next month, right? Something, still top off, just top it right off. We'll be all good.
Among friends, it's nothing.
We'll top her. I think that's totally right. All right, tell me this, because look, litigation finance is obviously something that no defendant wants to see, because it allows for the best lawyers and the best experts, so it's not asymmetrical. And because of that, there's a lot of things that are put out there by the Chamber of Commerce, other groups. By the way, like, it's their right; they can say what they want. I don't begrudge them for saying it. What do you think are some of, or maybe the most hilarious, whatever it is, misconceptions about litigation finance that you see in the market?
I guess a couple things. First, I'd say before, that about scale, it's not all there. And to think that, I don't know, pick your mega asset manager is going to come in and create such low cost of capital that it's going to revolutionize the litigation game.
LIBOR minus 10. That's it. That's what everybody wants.
Right. Exactly.
With a LIBOR floor of 10. That's right.
It ain't happening, or it's not happening. Well,
Evan, have you seen the version of this deck where it says the TAM is $8 trillion because that's what U.S. law firms billed last year, right? Like that one? Yeah.
No, and to the extent that that the litigation finance market is growing, it doesn't mean that litigation the addressable market is growing. It just means that it's risk shifting from contingency firms that for many, many years were doing this all on balance sheet, and it's being shifted off balance sheet. But it doesn't necessarily mean that the total addressable market is being shifted. I guess the other thing I'd say is that people are concerned about litigation finance, that the returns are so outsized. And I guess, my comments earlier could somewhat speak to that, okay, in some egregious situations, perhaps these things need to be right-sized to not be.
But any contingent fee case is the same thing, right?
I think that's right.
We took a third. So think of this, right? Like, we get 33% of this case.
Yeah.
Settled for $250 million. We did, 10,000 hours of work for $75 million. Right. It's it's sort of like, and
you're eating and for every one that you're hitting it on, or two that you're hitting on, you're probably eating it on one, because if you're not taking risk, you're not doing your job. So, lawyers deserve to get compensated for their work. They are expensive. So when, a lawyer asks for a healthy contingency, they deserve it, because they're also taking cases on that they're going to lose on.
And when they do it, and when they do it, especially with a corporate, because most, personal injury, is pretty much, there's kind of a standard formula. They're all going to charge whatever they charge. Mm-hmm. Some states, like, for example, New Jersey, I think caps it at 30 or 33%. But, when a sophisticated corporate says, we have a really sophisticated problem here, we're either going to get $0 or $400 million, and we need 13 smart people who work here to do nothing but this for 4 years. If you want them, you got to pay for it, and you got to pay for it some way. You either have to pay them hourly, you have to pay them. It just is what it is.
Right. Yeah, for sure.
Okay. All right. So I have two more for you. So you can. I'm going to kind of lull. This is like the deposition where I'm going to lull you, right?
The drums are going right now.
The drums are going. Okay.
You're an hour 6.5 of the deposition. You've led me down the wrong track already.
It's always after lunch, for sure. Okay.
Here comes the Whopper. Right. Go ahead.
So, what is your favorite part about this business? Besides the media appearances, I mean, those are huge, right? Those are massive, right.
I'll tell you what's not, candidly. I am financially proficient, and I've done modeling on litigation finance in a whole bunch of different things. There are people, though, that are absolutely smarter than me. on that stuff and some of the, really sophisticated financial engineering that's going on now. It blows my mind, truly. You have like credit investors who are doing pretty remarkable stuff. You have the insurers who are doing stuff that honestly, 10, 15 years ago, we're like, oh, that's just too good to be, that's just too slick. It'll never get to that. And they are doing that. So that's not the piece that is my forte. My forte, I'd say, or the thing that I find the most interesting is what goes into, building a lawsuit, what goes into the sausage, the underbelly of litigation, touching everything from, revenue recognition principles on, partner origination and things like that, what it takes in terms of hard costs and e-discovery and the true expenses of litigation. And what I find, I think, most interesting is, the essence of the asset class, or like the purest form of the asset class right now, I think, is that hasn't gotten too slick, is these cases that need between kind of $200,000 and $2 million. There's a ton of nuggets of opportunity in that space, and when you see transactions going down in that size, they tend to be relatively unsophisticated, and they tend to be, the needle in the haystack. But to watch, those transactions get put together, I think it's really interesting. And it's something I've always, that's always drawn me to the asset class.
Okay. And I guess my last one before my real last one is, I heard you have a podcast too.
I do.
Okay. So what I really wanted to ask you is, what's the response been? Have you heard from people besides just your friends in the business listening? Like what's sort of the reaction been about on that?
It's been great.
And maybe you can tell people what it's called and where to listen to it, but that's up to you.
I had this great guy on, like
your publicist told me to remind you to plug it. So there you go.
We do have a podcast that's also, I think, it's on LinkedIn and YouTube. I don't know how the kids these days with the computers. I don't know how it works. But we've touched on every aspect of litigation finance. We are pretty agnostic with respect to the types of disputes that we've handled in litigation finance. So we try to touch on all aspects of it. We had the big guy, Ted Farrell, on talking about mass torts. He was just stunning. We've had Professor Seebach on talking about legal ethical issues and alternative business structures coming out of Arizona. We're going to be doing one on the UK really soon, in the Packard decision and the kind of emergence of what
Packard, one of the greatest things that ever happened for price fixing in the world, right? Right? Like if you wanted to join a cartel in England, congratulations, right? Let it rip. Let it overcharge. Cat's not gonna do anything. That's right. They're not gonna do anything. So just let it rip. Get over there, Get over there. Do it.
We've had everybody. We've done patent litigation finance with Larry Rosenberg. We had Derek Ho on doing disputes in litigation finance. We had Dave on that one too. It was awesome, and it's been really great. We've gotten a great reaction. We have gotten people calling saying, "I heard it. What'd you mean by this? What'd you mean by that?"
When you said, "I don't know," I just wrote off the note card. That's right.
We were just making it up. We've gotten a really good response, and the podcast is continuing to kind of evolve a little bit, and we'll it's kind of matching how our own practice has evolved in this area as well.
So I think if I went on YouTube and hit like Slarskey podcast or something like that, I'd have a fighting chance of finding it.
Something like that.
Okay. And then, you have to sort of put somebody in maybe a tough position, but, all the people. So I'm looking for guests, right? I'm looking to really just drift, off of the work you're doing here. Who do you think might, the listening public would benefit from maybe coming on this one?
Well, you've had the best in the business on. You know a lot of the people.
You're doing it right now. I mean, look, I have right now.
I know. I mean, you've had me, so it's
yeah.
like,
We're taking down all the other episodes. By the way, they're going away. Those are done.
Yeah, look, the kind of the big three. Mike Perich, you got that covered. Don't get better than him. Derek Coe was fantastic, but I'd say Professor Seebach. Look,
okay.
The next frontier of stuff that I don't that is not my where we are focused on in the asset class is, I think, alternative business structures, be it Arizona, Utah, Washington, D.C., offshore, whatever the case may be. And Professor Seebach really has his finger on the pulse. It's incredibly, always incredibly thoughtful analysis, looks at cases from a completely different angle than what meets the eye. I had him on a podcast or a CLA years ago where we were looking at a class action case where the court brought into an inquiry concerning class certification the question of litigation finance. We're all sitting there, oh, this is so interesting. This is one of the rare exceptions where it might be admissible. And he looked at the room. He's like, you guys got it all wrong. We're like, how did you get it wrong, Professor? He's like, this is a court stomping off on the structure of this litigation finance contract. And we're like, oh my God, you're right. Wow. And it was just so interesting. I've known Professor Seebach for many years, and it never ceases to amaze me. Every time I interact with him or I bring him into some type of continuing learning thing we're doing, I learned something new. Fantastic, and I highly recommend having him on.
All right, well, you'll be CC'd on the email, and when he says who is this guy, you'll say don't bother, which is totally
who did new phone. Who dis?
Yeah, exactly. Okay. Well, Evan Fried, as always, it's been a pleasure. Slarskey LLC, and we'll talk soon, dude. Thank you.
Appreciate it.
Bye.